rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time it's set for oral argument in cause number CV 21-0503, Giselle Salinas versus Jason Thomas et al. These proceedings are being video and audio recorded as well as live streamed, so I ask you to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes in which to argue. Appellant, you are responsible for reserving a portion of that time for rebuttal should you choose. Also, we have read the briefs. We have discussed this case in conference. We're familiar with the facts and the arguments. Please bear that in mind during your argument. At this point, counsel, you may proceed.
Good morning. May it please the court. My name is Jay Calhoun. I represent Danielle Salinas and Giselle Salinas in this particular matter. Danielle Salinas and Giselle Salinas made a legitimate attempt to vindicate their legal rights in a court on causes of action warranted under existing Arizona law as allowed. Notwithstanding that, the trial court sanctioned Danielle and Giselle jointly and severally with their counsel, myself, and awarded approximately $27,000 in attorney's fees to counter defendants under ARS 12349, 1, 2, and 3, without setting forth any specific reasons for the award as required by our legislature under ARS 12350.
Counsel, let me interrupt, and I'm sorry to jump in so early. Assuming, for argument's sake, that we agree with you that there's at least a lack of required findings in the court's award below, which I think seems to be pretty clear. But setting that issue aside, how do we even hear this case? I know you have, in your supplemental briefing, I read it anyway as saying that you concede that the 54B certification is improper, but you're asking us to take special action jurisdiction. I don't see anything in this case that merits that. You could appeal the award of attorney's fees at the completion of the case when the litigation is done between all parties. Why are we jumping the gun now?
Well, we're jumping the gun. I don't see it as jumping the gun.
Or jumping the line, I should say.
But I see that we are asking the court for special action jurisdiction because there's no speedy equivalent to what an appeal is. We have no idea how long this trial is going to ensue, and the issues that are...
But that would be the same for any pretrial ruling. I mean, that means every denial of motion for summary judgment, every ruling you don't like during the course of a trial, every sanction would be something we'd have to take up rather than do what we're supposed to, the general rule, which is wait till the litigation is completed, and then we kind of piece through all the issues. Why is this one something we have to do now?
I agree with you. I think the court should not have issued a Rule 54B ruling. I think that's one of the problems that we have here, and we argued against that in the trial court, that the court could not grant a judgment. A judgment should not exist at this stage in the litigation under the cases that we cited in our brief, and I think one was Lee, and forgive me for the memory issue, but one was Lee and the other one was Naccio, where the court said that if attorney's fees is the only issue to be decided, that the court should not issue a final judgment on the merits. We still have an issue of the issue of the merits of the particular litigation, which no one can really address or move forward because of the particular ruling. So even if you didn't make a decision under special action, we're left with the Rule 54B judgment. We can't do anything in the trial court because there's a judgment that's pending, and so the litigation can never really be consolidated back, and we're going to be coming back with the same particular issues. And some of the issues in the appeal are issues that the court can review in special action. I think one of those was the issue related to the motion to disqualify, where the trial court believed that the state bar makes rulings related to pending litigation, and I think that's an issue that the court can look at as well. And your rulings and history has also determined that in situations like this, the court could accept special action jurisdiction if it chooses, and we're asking you to accept it and grant us the relief requested.
Help me understand, I'm sorry, one more thing before we go on. So because there's a 54B judgment as to the fees, you can't proceed with the rest of the litigation? I'm not following why there's
No, I'm not saying we can't proceed. We are proceeding with the rest of the litigation. We can't address the issues in the judgment because there's a judgment. And so we're stuck with this ruling in the middle of this litigation that we can't do anything with. If the court makes a decision related to those fees, and let's say you vacate, which is what we would ask you to do, and then let's say the appellants decided to move forward in some other way under the litigation, we would be free to do that. With the judgment pending, they're out of the litigation and there's nothing we can do related to the current counter defendants in this action. And I think
Could we then just vacate the 54B certification and decline to take special action of the remaining issues and send it back?
Then we would ask if the court would do that. If the court vacated the Rule 54B certification, sent it back, we would also ask the court to undo the award as well and let us.
But that would be exercising special action jurisdiction. I'm just trying to say.
What's the smallest way?
Yeah, what's the least, which I generally try and follow is I decide as few issues as possible. And it seems to me, and I don't speak for the panel, that at least as to the fee award, special action jurisdiction is premature. But I understand your position with respect to the 54B. So if we vacated the 54B, meaning that you could then appeal the fee award at the end of the completion of litigation, however this matter gets resolved, would that be an intermediate minimalist ground that would be suitable from your perspective?
Yes, it would, Your Honor. However,
I'm not asking for a concession. I'm just saying, tell me, all I'm asking is tell me if I'm crazy. How about that?
Oh, I would never tell you if you're crazy.
You're free to.
Yeah, we do that. I would argue that, yes, minimally that would get us there, but I think that the whole judgment needs to be vacated because I think the issue surrounding it in terms of the court's determination of why the court even determined that it could grant sanctions without finding any specific findings of fact still lingers in the particular matter that would need to still be addressed within the context if we decided to move forward with the counter defendants in the litigation. So if you remove that, it removes the judgment. I don't know how it puts the counter defendants back into play or into conversation or address some of the issues that we have regarding the particular litigation. I think there were several, the one regarding the motion to disqualify, which the court can address on special action as well, and some of the other issues that we raise in the appeal.
Are you required to pay the sanctions now, or?
Yes, the judge ordered us to pay it or that he would have them take our personal possessions, and so we didn't have an option.
If we were to vacate the 54B judgment, then that would go away as well?
It depends on how the court writes the, if the court reverses the 54B judgment and to say, okay, Judge Howe, let me see if I understand. If the court vacates just the language of the Rule 54B to say that the appeal, that the court couldn't determine it as a final appealable order, that's one thing. But if you vacate the substantive part of it, which would be different, I think there's a procedural and a substantive component. That's how I'm envisioning it. And I think you would have to vacate both.
But to do that would require us to exercise special action jurisdiction, correct?
Of course, and I'm arguing.
I understand that's your argument, but if we took the minimalist approach and vacated the 54B judgment, would you still have to pony up your money now?
We had to pony up the money. The court ordered us to do so, or that he would seize our personal assets. So we had to pony up the money in order to get here. The judge would not let us move forward. And we would like to have that vacated so we can remove the bond on this particular issue and move forward. So yeah, that's one of the issues that presents itself, why we need the substantive, or the court could just vacate the bond and then and have it released back to the parties until this matter concludes itself as well. And that's why we requested special action, in addition to all of the other unique procedural issues that I've never seen in any particular case in this court or in our Supreme Court, in the appellate courts. For example, filing a Rule 541A voluntary dismissal and having the court determine that even though the appellants complied with the rules and filed it within the timeline within the rules, that was not reasonable as well, without giving us an explanation as to how that particular issue worked as well.
Can I ask a question on the kind of the semi-merits question? We've talked about jurisdiction a lot. Your argument on the disqualification motion is that, at least as I understand it, is that the court erred in not holding a hearing, at least, right?
Yeah, we argue that the court, not only that it erred in not holding a hearing, it erred by doing a paper trial, comparing this email from the State Bar, Ms. Cassetta, who I've never met, we don't have paperwork from her, comparing what she wrote and holding that to be the credible issue and not allowing the litigants to even have an opportunity to present its side. We asked for the evidentiary hearing because the counter defendants...
When did you ask for the evidentiary?
We asked for the evidentiary hearing during the oral argument.
Right. That, I'm not sure, but that seems late to me. Normally you ask for a hearing at the beginning of the hearing. You don't wait until it's been fully briefed and you're arguing the case and you realize things may go or aren't going your way, and you then ask for evidentiary hearing?
No, I think that's a mischaracterization, Your Honor. We didn't wait at that time. The court raised the issue during the oral argument that Ms. Cassetta's email was an opinion of the State Bar. I didn't have that information when I drafted my brief. I didn't know when I drafted my motion to disqualify that counter defendants were going to put in an email from the State Bar arguing that the State Bar had already resolved litigation issues. So I didn't understand the extent until we went to oral argument and the court questioned me about it and asked me to defend or explain what the State Bar is doing. And I can't explain what the State Bar is doing because we don't have access to that as attorneys in terms of the State Bar's investigation or charges related to an attorney. And so those issues were raised orally at oral argument, and that's when I said to the court, we need to have an evidentiary hearing because my client is saying these attorneys were the mediators for her family's pre-litigation dispute. The attorneys have said we're not. And the court said the State Bar has litigated this matter, making the assumption somehow that this is res judicata. So I was kind of caught off guard because I've never had any of these issues appear. I've never seen anything like this in my career, in 20 years as a business attorney in Arizona, to have a judge tell me that the State Bar has determined a legal matter in a pending proceeding. Yes, that's when I raised the issue, when I realized the court was misunderstanding and he was making us defend or explain something that we couldn't. And so that's why a hearing is necessary.
Your argument seems to be, though, that the court misapprehended the legal status of the State Bar's finding. Why would an evidentiary hearing help resolve that? So, well, I think of evidentiary hearing when you're dealing with the credibility to resolve credibility issues, and they're necessary, and Volk is the case I think you cite for that proposition.
Right.
I don't see the credibility determination here. So help me understand what it is that they would resolve the credibility of.
The credibility is the court decided that a litigant in Arizona state courts is not entitled to be heard on their issue for the court to hear that someone was their attorney. That the court determined that what the State Bar wrote, this email, is more credible than what an actual litigant has to say. So there is an issue of credibility. Her statement, at
least her affidavit, just seems to be kind of, I believed, which I don't know if that raises an actual factual issue for the court to determine. I don't know, is her belief as to his Are there representation? Is that sufficient to require disqualification?
No, it's not, we didn't even get to disqualification. I think it raises the issue to allow a litigant to be heard on the particular issue about whether they believe someone was their attorney. And I think the only way we can do that is to hear from the counter defendants, which we didn't hear. They didn't file a counter affidavit in that particular matter. So we're dealing with the factual issue, dealing with credibility. The court just automatically assumed that the state bar somehow litigated this particular matter, and that what this email was the more credible of the two pieces of paper that were addressed. And what we were arguing is that is not how the court should have addressed an issue of credibility. If the court believes that the state bar litigated the matter, and I don't know how, the court could either bring the state bar in to the proceedings and ask the state bar questions, and have the counter defendants ask questions as well, and allow the appellants and defendants to present their side of it as well. And that's what they were asking the court to do, is to hear them. I don't think it's very easy to share a non-sophisticated person's belief over an 8-month period, dealing with an attorney who they believe was the mediator for their family, to explain all of that on paper. And I tried to be very careful in doing that without violating some of the ethical rules myself related to those particular issues. And even if we had drafted a 20-page affidavit, the opposing counsel and party would have still said, no, that's not accurate. And we would have still been back to the same place we were. It needs to be heard. I believe it needs to be heard, and we're asking the court to address at least that particular issue. I understand limiting special action at this stage, but I think that's a very important issue because it is relevant to the current pending litigation in this matter.
I don't know if you wanted to reserve time, but you've got 4:30 left.
I did want to reserve time. I just want to finish up quickly that Stacey Ritchie provides that the trial court, there's a heightened standard in terms of findings of facts that the court must address in their ruling. And the court failed to make those findings, and it failed to require the proponents of the fee award to present any evidence to demonstrate that, to meet their burden to prove that the complaint was groundless and bad faith. And we would also ask the court to take note that the court's ruling doesn't even address groundless and bad faith. It just cites the statute as well. I'll reserve the remaining of my time, and thank you.
Thank you.
Thank you.
Good morning, and may it please the court. Jamie Glasser appearing with my partner Miles Hassett for Appellee's attorney Jason Thomas and law firm Iannatelli Margolini PC. Before I get to the issues and asking this court to affirm the trial court's ruling on sanctions, I'd like to address some of the key facts established on the record at the trial court. Without the involvement of lawyers, Richard and Petra Salinas executed a contract for the sale of their Mexican food restaurant to their nieces, Danielle and Giselle Salinas, the appellants. A dispute later arose regarding the contractual terms. After the dispute arose, Richard and Petra retained my clients, the attorneys. As litigation ensued, the attorneys filed a lawsuit on behalf of Richard and Petra. The appellant's response wasn't just to answer the lawsuit, but was to file a counterclaim against Richard and Petra, but not just against Richard and Petra, also against my clients, the attorneys, alleging that they aided and abetted fraud, tax evasion, and bad faith. Our fundamental argument is that suing the attorneys is not supported on these facts, where the attorneys were acting
Before we get to the merits, and I interrupted you about the same time I interrupted her, so I apologize to both of you, but help me with the jurisdiction. I read you guys were in the strange position of an appellee arguing that a 54B certification was correct. Well, the appellant is acknowledging that it wasn't. What is your best argument for why this 54B certification was proper?
Well, thank you, Judge Morris. And I believe Ms. Calhoun actually stated it well in her brief, opening brief, page 31. Nothing that could occur in the trial court would likely alter the disposition of the issues raised in this appeal. She said that in the context of asking for special action, but that statement remains true. There's no ongoing dispute between the attorneys and the appellants. There's nothing to be litigated, and nothing that happens at the trial court is going to affect the propriety of what's happening in this appeal.
But in fact, hasn't she had to tender a bond to cover that amount?
She has. My understanding is the bond has been tendered, and that's in the normal course of an appeal. You tender a bond.
Right, but the only reason there's an appeal is because there's a 54B certification. Otherwise, you would wait till the end of the litigation and resolve whatever issues on appeal you wanted to raise.
From the appellee's
So, I mean,
perspective-
our point being it caused something to happen. So it actually did impact the ongoing relationship between the parties, or the ongoing litigation between the parties.
Judge Morse, there is no ongoing litigation between the attorneys and the appellants. That's over. So there's nothing further to be litigated at the trial court that's going to have any effect on this appeal.
When you say it's over, it was dismissed without prejudice, which means it could be refiled, correct?
Subject to statute of limitations and good faith bases, it could be refiled.
How close are we to the statute of limitations on this?
It depends on when that statute accrued, Judge Howe. My understanding is the claims here are for bad faith. That would be a 2-year statute that may have already expired at this point. The fraud, I believe, is 3 years, and that's probably running or close to running its course as well.
So if we back ourselves out of the specifics of this, we have parties that have been dismissed voluntarily. We have a judgment against opposing parties in counsel. At what point could they bring this up and have it reviewed by this court, in your opinion?
Well, that point is now, after the court made its ruling, after the claim was dismissed.
But you agree with me that special action jurisdiction is a discretionary kind of review by this court?
Absolutely.
So when would this court have to mandatorily review the judgment entered against your opponent?
I believe it's when the 54B final judgment language is included.
But a 54B final judgment is only appropriate when it's final, and we have a dismissal without prejudice. So that was the question they were asking earlier, which is where I'm getting hung up, is how can this 54B, when it's not final because it's without prejudice, be final, as between the appellants and the law firm?
The judgment that the appellants are appealing from is not the dismissal of their claim, it's the sanctions award. So that is final, and nothing that's going to happen in any litigation that could be brought if the statute of limitations were open would affect that. They are separate, and that's something that the appellants concede in their brief. These are separate issues.
So your position is that the fee award is separate from the dismissal, and that the fee award should be independently appealable because it's a final judgment.
It's that those issues are separate. As the appellant said, nothing that happens in the trial court, if this claim is brought
But
back.
54B says all matters have to be final between the parties, not just the fee award. So again, we have a voluntary dismissal of the claim without prejudice. So there's still the not final matters between the parties, at least according to a whole bunch of cases that have been issued from our court and the Supreme Court saying that a dismissal without prejudice is not final. So I get you're saying the fee award is final, but are all matters between the parties final?
From our perspective, they are subject to the hypothetical bringing back these claims for aiding and abetting tax evasion. I believe that they are.
Putting the statute of limitations aside, if the claims were refiled, they wouldn't be final. Correct?
If the claims were refiled, then those claims would not be final, but that would not alter the sanctions award.
But if that's intertwined, I can all matters between the parties be over?
I believe it was in the Ham versus Y&M case where this Court of Appeals stated that 12349 sanctions could be appropriately awarded even if that party that gets that award ultimately loses the case, meaning that those issues are not necessarily intertwined.
Would the dismissal be final because, and I don't know, I'm asking, would the dismissal be final because the statute of limitations may have or will run?
If I'm understanding your question, Judge Howe, you're asking, does the underlying claims become final once the statute of limitations has run?
Mm-hmm.
I believe that would be the case, yes.
Okay.
Now that I threw you off track with the 54B certification, why don't you make your best case for me that we should accept special action jurisdiction to decide this case now?
Well, Judge Morse, we're not asking to accept special action
I'm
jurisdiction.
saying, taking a hypothetical that I didn't think you made a good case on 54B, just a hypothetical, that means we don't have anything here, other than maybe finding that the 54B certification was improper and vacating it. If that's the case, should we take this case? Should we exercise special action jurisdiction to decide this case?
We believe our clients deserve finality to these issues regarding the sanctions. They have incurred these litigation expenses, and there's really nothing that's going to happen that's going to alter that. That's what the Ham versus Y&M case says, is that these issues are not intertwined. And so this is an issue that, if not now, when would be an appropriate time to address this? The case between the attorneys and the appellants is over. There's nothing further to address there, and as stated, these issues are not really intertwined, and so we believe it's appropriate for finality. This is, whether it's an issue of statewide importance, I would leave that to the court to decide. But
So let's say we don't believe it's an issue of statewide importance. How does your opponent get redress for the issues that are before this court in the special action? Doesn't have a right to appeal. The case is still, I mean, do you see my question to you is, you have a right of review. When does that right kick in your understanding under this kind of a circumstance?
Well, Judge Campbell, the court included Rule 54B language, so that really kicks into gear what has to happen from there in terms of the timeline. So once that trial court makes that decision, then that's when it starts the timeline for having to file an appeal.
More questions?
I can address
I
non-54.
derailed you. Why don't you get back to your main argument there?
I appreciate that, and I'm happy to address any more 54B questions, but if there's none right now, I'll move on to some of the more substantive points. Another fundamental argument is that suing the attorneys is just not supported on these facts. The attorneys were acting as lawyers for their clients and became involved only after a dispute had already arisen. We believe that the appellant's counterclaim is bogus, it was tactical, and its bad motive was obvious. The conduct was tactical because it aimed to interfere in the attorney's relationship with their clients, Richard and Petra, for strategic advantage. As soon as they sued the attorneys, they moved to disqualify them.
Where in the record can I find the findings necessary to support that ruling? Because I agree with your opponent's counsel that, at least as far as I see, all the court did was cite the statute, and the statute requires that the court make explicit findings, and I don't see those findings. So where can we find them?
Judge Morse, the court did...
Or tell me I'm wrong if they're about the requirement to make the findings.
Well, this court in Phoenix Newspapers versus Department of Corrections explained the reason for why findings are required. The purpose of this requirement is to assist the appellate court on review. Thus, the findings need only be specific enough to allow an appellate court to test the validity of the judgment. The trial court's ruling was not made in a vacuum. The claims had no merit on their face, and the obvious motive was to disqualify.
Did the court make a finding that the claims have no merit on their face?
It made a finding that the claims lack substantial justification.
Where's that?
That's in the June 17th, 2021 minute entry. It is further ordered granting the attorney's sanction motion. The attorneys are correct that the prosecution of the claims against them by Danielle and Giselle violated 12349 in the following particulars. Danielle and Giselle and their attorney, Ms. J. Calhoun, brought claims against the attorneys without substantial justification, brought claims against the attorneys primarily for harassment, and brought claims against the attorneys that unreasonably expanded these proceedings. These are similar findings that this court has upheld in cases like Harris versus Reserve Life Insurance Company, which is cited in the papers. The court also, later on in this minute entry, stated, the court makes a specific finding that the voluntary dismissal filed by Danielle and Giselle on April 16th, 2021 was not made within a reasonable time after Danielle and Giselle or Ms. Calhoun knew or reasonably should have known that the claims against the attorneys were without substantial justification. So the court did make those specific findings. And most specifically, as just stated, with regard to the timing of the dismissal. And we believe that's key here because my partner, Mr. Hassett, had conversations with Ms. Calhoun very early on, before filing a single paper with the court, asking for dismissal or anything, explaining, you've sued my clients on a counterclaim. They're not a party to the lawsuit. That's not appropriate. Can you, at a minimum, put it into the proper pleading format, which would be some sort of third-party claim or some other sort of claim, presumably. And Ms. Calhoun and her clients declined to do so. So the case went on and on. We filed the motion to dismiss. We argued and briefed the motion to disqualify. And so the timing of it is really critical. This court has found that unreasonable delay in filing a voluntary dismissal can form the basis and does form the basis of sanctions under 12349. And that's what the trial court did here. It found that the delay was unreasonable.
Your client had not filed a responsive pleading, though, to the underlying claims. Is that accurate?
No answer was filed, Judge. We filed a motion to dismiss.
Okay. And doesn't our cases, or don't our cases say that in the absence of an answer, even a motion to dismiss it, there's nothing that the voluntary dismissal or notice of voluntary dismissal is sufficient?
Under Rule 41 and 12349, it must be made within a reasonable amount of time. It was not made here in a reasonable amount of time. That's what Judge Daniel Martin found.
Okay.
Can you address briefly the significance of the State Bar email? We spent a lot of time in your opponent's argument talking about the presentation of this and how it came into play in the motion to disqualify. So can you address that briefly?
Thank you, Judge Campbell. And my opponent indicated that the State Bar email, or that the State Bar determined a legal matter. I'm just writing down the notes I took from what she stated. The State Bar did not determine a matter in the trial court proceedings. Judge Martin reviewed the email from the State Bar, which summarized a lot of the communications between the parties, and the State Bar did conclude that there was no basis for a bar charge. But the underlying information that the State Bar included is what I understand Judge Martin reviewed in making the determination that there was no basis for disqualification. That included, for example, emails from the attorneys to the appellants, subject line, attorneys for Richard and Petra Salinas. It included observing that the communications between the attorneys and the appellants was adversarial, observing that there was no indication of advice given by the attorneys to the appellants, and no confidential information or privileged information shared from the appellants to the attorneys. So this is the information that the State Bar included in its email dismissing the bar charge against Mr. Thomas.
Why was it appropriate for the court to consider that information outside the confines of an evidentiary hearing?
It's information regarding the issue on disqualification. There's really no dispute as to the authenticity of the underlying information that the court considered. And we believe there's really no issue for credibility. Judge Morse, I believe you indicated that earlier. You didn't really see any credibility issue, and we agree. Credibility is not at issue. This court has perhaps reviewed the declaration of Giselle Salinas, and that, I believe, is one of the key documents that they rely on for the supposed notion that the attorneys held themselves out as the family lawyer. In the appellant's brief, they pervasively describe that Mr. Thomas called himself the family lawyer repeatedly, continuously called himself the family lawyer, and the only document they reference for that statement is this declaration. That's not what this declaration says. Paragraph 7, during this time I called Mr. Thomas, our family lawyer, related to the contract dispute and financial matters. Mr. Thomas did not hold himself out as a third-party neutral or as a family lawyer for all of the parties. He made very clear in his communications that he was the lawyer for Richard and Petra. I observe that I have about 2 minutes left, so I'd like to give a closing statement and recap. The trial judge, Daniel Martin, reviewed the record. He observed that the appellant's aiding and abetting claims lack substantial justification. There's no civil action for tax evasion. You can't aid and abet tax evasion. There are no facts alleged, even described in the briefs by my opponent, that connect the supposed bad faith and fraud to my client. There's nothing. And Judge Martin found that those claims were brought primarily for harassment and that they unreasonably expanded the proceedings. Judge Martin specifically found that the appellant's counterclaim was not dismissed within a reasonable time. These findings are supported by the record. And recall, that's the purpose of the findings, is to give this court a basis on which to affirm or not the findings. When you bring a bogus claim for bad reasons against the other side's lawyer, you can't avoid sanctions by perpetuating that claim at this appeals court. If the appellant's conduct were allowed to stand unchallenged, there would be a chilling effect on attorneys who seek to advocate only for their clients, as Mr. Thomas and his firm did here. That would deter attorneys from representing clients in need against litigants like Salinas and counsel like Ms. Calhoun. Lawyers in Arizona ought not to be forced to incur attorney's fees, report a claim to their E&O carrier, and otherwise become parties to an action and possibly disqualified as a tactic by the other side. That's what happened here. The trial court's ruling sanctioning the appellants for their wrong conduct was not clearly erroneous. It was clearly correct. We respectfully ask this court to affirm the trial court sanctions ruling and further grant the request for attorney's fees and costs on this appeal. Thank you.
Thank you, counsel.
I just want to address a couple of items. We did not file, Giselle and Danielle Salinas did not file a bad faith claim. That's an insurance claim, so they didn't file that against the defendants' appellees. They filed a aiding and abetting fraud and aiding and abetting the good faith and fair dealing of a contract that they signed in which their aunt and uncle sold them nothing, and we're still in the middle of litigating those particular claims. I noticed that my opponents claim that the record states a whole bunch of things, but they never cited to any specific place in this particular record, nor in their brief, where the court made any factual findings that Danielle and Giselle and counsel made any attempts to not bring a legitimate claim. And on a policy note, it's saddening that a court would dismiss appropriate claims. Aiding and abetting has been around in the state of Arizona for a very long time. It's a legitimate claim. And to have an opposing party, a lawyer, stand in front of a court and argue that aiding and abetting fraud is not a valuable claim, not move towards discovery, and that the parties didn't have a right to be in court is troubling on a particular matter.
You dismissed that claim without prejudice, so
Yes, we dismissed both of the claims without prejudice, but not because they didn't have merit, Your Honor. And Rule 41A1 doesn't say you have to provide a reason.
No, I get that. You just said they said you shouldn't have your day in court, but there's no day in court because you dismissed the claim.
No, but they're arguing that they didn't have a right to even bring the claim. It's a legitimate claim that they did have the right to bring. That's what I'm arguing, that no court says that you can't bring a legitimate claim against someone and vindicate your rights. And there's no authority that says that you have to have all of the facts related to the case when the opposing party obstructs discovery and have all of that available at the day of a pleading. That is not how our system works. We're allowed to do discovery. And so, but that's a different issue than what we're here to discuss.
Well, Counsel, how is finding that it was brought without justification for harassment and unreasonably expanded the proceedings, how there sounds like certain findings to me?
That's a quotation of the rule.
Of the rule?
Of the rule as well. The court made no findings. The person who filed all of the motions was the opposing counsel. We filed a pleading. Litigation is not expanding the proceedings. It's litigation. You have to do certain things that's involved with it. We filed a counterclaim.
Well, what would the court have to say? Is without substantial justification because?
Well, the court has to, according to Rule Arizona ARS 350, the court has to identify specific factors and ask. The court didn't say that the claim was brought under 12.3, I think it's 12.349F, where you have to address bad faith and groundlessness. Aiding and abetting claim is not groundless because you don't know all the facts related to the particular party at the pleading stage does not make a claim groundless.
But you agree with me that before filing a pleading, you have to have a reasonable basis to believe that a claim is applicable and will be able to be proven, correct?
Exactly, and we are able to do that, and we could have moved forward on that particular issue. The clients did have a reasonable belief. Just because you have a dispute, one side doesn't get to say up front, your claim is invalid because I don't want to be in litigation. That's why we do discovery, right? There was no discovery to bear out their side. There's no affidavit from any party, any defendant saying this isn't true. All we have is arguments by their counsel, nothing from their opponents. And if they believe this claim was invalid, why did they submit 650 bait-stamped emails into the records from their own law firm, into their clients? So we have issues, Your Honor, that are related. You want me to go? I see you pointing.
Your time is run.
Okay. Oh, my time is run. I'm sorry. Please vacate the judgment.
Thank you, counsel.
And grant special action.
Thank you, counsel. We appreciate your arguments here today, your filing of papers. We will take this matter under advisement and issue a written ruling in due course. At this point, we are in recess in this matter. We will stay on the bench as we reset the courtroom for our next argument in Morado versus Bustamante.